Welcome to our second lecture covering Chapter 9 of our textbook. Let's go back to the beginning of Chapter 9 and do a little bit of review and then dive into the new material. As we covered in the first lecture, we are talking about the topics of performance and discharge with respect to contracts. In the first lecture, we covered the topic of performance, but just a little bit of a review. Performance is the doing what you have agreed to do in the contract. Then we spent a lot of time talking about conditions precedent, conditions subsequent, and then we moved on to the topic of discharge. We talked about discharge being the release from a contract either by agreement or by carrying out the obligations. And we talked about RRAN, we talked about the four ways that we can have discharge. The Plano approach. We don't actually have an L, but Plano other than missing the L here. We talked about performance and breach and substantial performance. And we talked about agreement. This is where we got into the RRAND. We talked about rescission, which is cancellation of a contract by mutual agreement. We talked about release and accord and satisfaction. These are really the same things. And then we talked about novation and discharge by contract terms. I want to go back and talk a little bit about novation in a little bit more detail. So right now we've covered performance and agreement, but I'm going to just spend a little bit more time on novation. Let me remind you what novation is. This is when we have our two parties to our contract, A and B. B, for whatever reason, needs to drop out of the contract. So A and B agree to make this contract go away because A is entering into a contract with C. C is replacing B's role in the contract. If C messes up, A can't sue B. A can just sue C. If A messes up, C can't sue B. C can only sue A. B is no longer a part of the deal. That's what a novation, change the parties novation is. Let's talk about a different type of novation. And you have this posted in Canvas. So you might have seen this picture of this cute little lad. The actor who plays the role of problem child is named Michael Oliver. Of course, he was a little guy at this time. This movie was probably made, I guess, in the 80s, maybe 90s. It's been quite a while, and so my guess is he's probably obviously significantly older. Anyway, when they made Problem Child 1, it was kind of a takeoff on Home Alone. The idea was get a cute little kid and throw him into a variety of situations, and the audiences would flock to the movie. As oftentimes happens with knockoffs, you're not quite sure if they're going to be successful. I mean, obviously, if you think back to the Home Alone movies, they really turned on Macaulay Culkin's charm and personality. And so the issue was, is this Michael Oliver going to be as intriguing and as interesting to watch as Macaulay Culkin was? So when the studio and Michael Oliver, or more likely Michael Oliver's parents, entered into this agreement, they negotiated. And they said, well, Michael's going to be paid $40,000. Let me make this a bit larger. So he's going to be paid $40,000 for the first movie, and he was guaranteed, because of course they thought to themselves, hey, Home Alone had all these sequels. If we need a second movie, Oliver will be paid $60,000. And that makes sense because they're obviously only going to make a second movie if the first movie was successful. So in some sense, Michael Oliver will have proved himself. At this point, while $40,000 is a lot of money for a kid about 10 years old to be making, still, in terms of Hollywood movies, $40,000 for the lead actor isn't very much money. So they make the first movie. Michael Oliver is paid $40,000. Everybody's happy. And they get especially happy when this movie becomes a huge hit. It gets $53 million. And think about the fact that you're not paying, Brad Pitt $10 million to be in the movie. So there's almost no salary issues with respect to this. When they go in to do the remake, the studio agrees to increase Oliver's pay from $60,000 to $80,000. Kind of a, hey, you did a great job, Michael. We want to acknowledge that. I guess it should be Problem Child 2. Okay, but before they actually start shooting Problem Child 2, Oliver's family renegotiate the contract, and basically they say to the studio, Michael's not showing up. $80,000, while nicer than $60,000, is a pitiful amount of money compared to the $53 million that you made in the last movie. And so we want at least $250,000 for Michael's role. Part of it, just reflects the fact that he is the main guy in the movie, and a smaller player in the movie, John Ritter, who was the bigger name, was getting a lot more money than Michael Oliver, so that was kind of an additional idea. There was also an option for Oliver to earn more money if the movie was the same type of success as the first movie. Of course, sequels are always kind of risky. Maybe they'll be successful, maybe they won't. And so this money was guaranteed according to the terms of the new contract, but this money was in play. It could happen or not. So after the movie was made, after Michael did his acting for Problem Child 2, the studio who made the movie said, wait a second, I know we said we wanted to pay him $250,000 plus this potential to make $250,000 more. I guess this is the salary and this is the more. But there was no consideration for this change. Under the original contract, where he was going to earn $60,000 and then later the $80,000, Michael was supposed to make Problem Child 2. Under the revised contract, where he had the potential to earn $500,000, Michael was supposed to make Problem Child 2. So there's no additional consideration that Michael is providing, and yet he's going to get so much more money. And in fact, Universal said that the only reason they renegotiated for this more money was economic duress. And basically, their opinion was that Michael basically held the movie hostage. Since Michael was in virtually every scene of Problem Child 2, his decision not to come to the set was costing Universal a lot of money and was throwing a lot of people, out of work. And so the studio said, look, the second contract with all these additional goodies ought to be thrown out. Oliver ought to be forced to return the extra money. He got $250,000, but he should have just gotten the $80,000. So he should be forced to return that amount of money. And in fact, the Universal Studios won because there was no additional consideration. So this is another example of a novation. This one isn't a change the parties novation. This is let me go back to our picture here. This would be, we have A and B, and then we still have A and B, but now, oops, sorry here, the parties have different duties. So now A had to pay $80,000, and now A is going to have to pay $250,000. So we need to have, in order for this change or this novation that requires more pay to B has to also have to do something more. Since there was nothing more that B was going to be doing under this novation, it was null and void. Now, of course, if Michael had been cleverer or his family had been clever, they would have put additional burdens on Michael. For example, make Michael do more publicity appearances and interviews. Again, the courts aren't going to really spend a lot of time saying, well, is the additional stuff that Michael or B is doing really worth $170,000? Of course, we're really not going to get involved in that. So let's say the original contract for Problem Child 2 required that Michael do 4 hours of interviews. Well, they could have simply increased that to 5 hours of interviews and paid Michael the extra $170,000. Most likely the court would find that adequate. So the problem was A's obligations changed, but B's obligations didn't. Again, this is another take on the topic of novation. Not a change the party novation, but a change the terms novation. Okay, so now we have completed our RRAND, the way that we can have a discharge of contractual duties by agreement. At this point then, we are up to our third of our 4 elements. So again, in order to have discharge, we can have it by performance. We can have it by agreement. So here we have for performance, we have a little bit of a reminder here. We have the Plano. I'm going to put the L in parentheses because we really don't have anything for the L. And then we have the R rand here. And now we're going to go into the non-performance. We don't have a mnemonic for this one, I'm sorry. But these are relatively short lists. I think they're fairly intuitive. We've already kind of talked about this last one. When one party makes a material breach to the contract, the other party is excused from performing. When A is supposed to paint the barn and B is supposed to pay A, and A doesn't paint the barn, B doesn't have to pay. It's not a breach for B not to pay. So we've kind of talked about that a little bit already when we were talking about performance. But let's go from the stop and talk about these. These are some of my favorite scenarios. They're kind of playful a little bit. So the first is impossibility of performance. When we talk about this, we're really talking about the laws of physics. We're talking about there is just no way to do what we said we were going to do. We're not saying it's difficult or impractical or just really awful or unfair. We're saying it's impossible. So examples of impossibility would be, let's say you have a barn and I'm supposed to paint your barn, but a tornado comes in and blows the barn away. There's nothing for me to paint. Even if I really, really want to and I'm willing to invest as many resources as I can, I don't have any surface to put my paint on. Now you could imagine a circumstance where the barn is very badly damaged by the tornado, but it's still standing. Logically, a person would think, it really doesn't make sense to paint the barn in its current state of disrepair. It's more important to get it repaired first and then to give it a good paint job. That makes sense. That's logical. But I could still paint it. The laws of physics don't prohibit me from painting it, even if it's a mess, even if there's lots of missing boards that are going to have to be repainted anyway, but they're not there right now for me to paint. So in that situation, we wouldn't call it an impossibility of performance. Many times when we're talking about impossibility of performance, we're talking about kind of acts of God situations. The tornadoes, the floods, the hurricanes, some kind of natural disaster occurs and it just is impossible to do what we said. But it's not limited to those. The term force majeure is kind of bigger than the idea of act of God. And by the way, act of God doesn't have a religious meaning necessarily. We're really talking about natural disasters. Things like hurricanes, volcano, eruptions, fires. But force majeure is actually broader than act of God because it would include man-made behaviors like wars, strikes, civil unrest. Those things obviously aren't natural disasters. They may be motivated by a natural disaster. For example, you might have a hurricane and then find there's local unrest as a result of that. But the actual local unrest are individual people deciding to riot in the streets or whatever. So force majeure is a bit broader than the idea of act of God. But the important fact with force majeure is it's something big. I mean, something really significant has changed and is out of the control of the parties. If I'm the one engaging in unrest, then I certainly can't use my own unrest as an excuse for getting out of a contract. But when other people about whom I have no control engage in unrest, then I can say, hey, it's not my fault. I can't stop them from doing this or that. So it needs to be something really big, and it needs to be something outside of my control, and it needs to be something unexpected. And when we have all of those elements, we have a force majeure. Now, certainly there are parts of the country that routinely have hurricanes, so you could say in some sense, well, it's not really surprising when the Florida Keys gets a hurricane. That's true, but if it's a truly bad hurricane, we could say it's surprising in the sense that that doesn't happen every year or even every few years. It's an expected thing in the long scheme of time, but it's not particularly expected in a given year. Similarly, with a volcanic eruption, we might say, well, that a volcano erupts every 200 years or every 100 years, so we know it's going to happen. So in that sense, it's not a surprise, but it's a surprise when it decides to happen in year X as opposed to year X plus 40 or something along those lines. It's very common to have a force majeure type clause in the contract that excuses performance under those circumstances, but it's not strictly necessary to have it. It's going to be implied. The court's going to recognize, hey, if a hurricane comes through, nobody's painting any barns. That's just kind of common sense. So while it's a good idea to include the clause, if you're missing that clause, you shouldn't feel like, oh, I can't rely upon this type of defense. So again, we're talking about physics. Is it possible to perform? But let's consider the next level. Or actually, here we've got some situations where we have situations where there's impossibility. Destruction of the subject matter of the contract. A classic example of this would be the barn has been blown away by the tornado. Another is supervening illegality. Going back to our premise, you could say here that the laws of physics aren't violated. Let's say we have here the example of prohibition. There was a day, I don't know if it was immediately active on January 16th or what, but there was a day that it was lawful to buy liquor and wine on day X, but on the next day it was illegal. Presumably there were various contracts out there that liquor and wine and beer distributors had with various restaurants and individuals. And so on the date that it became illegal to complete those transactions, those contracts became null and void. In a sense, the laws of physics didn't prohibit those contracts from being fulfilled, but the laws of physics prohibited those contracts being fulfilled in a legal manner. And you remember we have those 4 elements of contracts. Let's just do a little refresher here. We have our elements. We need to have an agreement. And we talked about an agreement needs an offer, an acceptance. And then we also need consideration. This has to be something both parties are either giving to the other party or it's either a benefit for the other party or detriment for themselves. It can be money, it can be services, it can be forbearance. And we also need capacity. All the parties to the contract have to have legal capacity. And then we have our final requirement, which is the one that is relevant to this one, which is it has to be legal. So the rules of physics prohibit us from entering into a legal contract after or when prohibition begins. So the illegality requires that we remember what our elements of contract law are. The death of the provider of a unique service. Let's say I'm a portrait painter. You hire me to paint the portrait of your great Aunt Mabel. If I die before it's completed, it's possible that someone else can paint the portrait, maybe even do a better job of painting it. Perhaps even that person could mimic my style, but it wouldn't be me, and there would be some differences. My painting, even if I'm not talented at all, is in some sense unique. Similarly, if I were a flute player or a ballet dancer or a novel writer, all of those things would be unique services. And when I die, I'm not going to be able to continue to do that. Examples of things that aren't unique services would be probably teaching a class. I suppose if I were a world-renowned constitutional expert in contract law or whatever, then my services might be unique, but honestly, contract teachers are pretty fungible. One of us can teach or another one, and there's not going to be a tremendous drop-off in the knowledge level of students. Another thing could be my barn painting. I mean, yes, I'm especially good at painting barns. I grant you that. But honestly, pretty much anyone can do an okay job painting barns. It's not exactly, the Last Supper in the in the Vatican City or anything along those lines. So there can sometimes be a debate about what's a unique service and what's not. But in theory, if it's a unique service, when the provider dies or becomes disabled in some sense and unable to perform the service, for example, let's say I lose my vision, or I'm right-handed and I lose my mobility in my right arm, then that could create an impossibility of performance. well, I guess here we kind of cover death here. We also cover disability here. Disability of a party whose performance is essential to the contract. So let's imagine that when I was painting Great Aunt Mabel, she was my live model, and that's the only way, but it's in the contract that Great Aunt Mabel has to make herself available for at least 5 hours to be, model for this picture. But unfortunately, and she's supposed to do a variety of things, pose, be able to change her expression. I need to be able to see her eyes. And unfortunately, Great Aunt Mabel has had a stroke, and she's bedbound and isn't able to move around. Even though, she isn't the one doing the painting, her participation is essential for me to be able to do my part of the task. And so you could definitely argue that her disability makes it impossible for me to perform the contract, and so there could be discharge by non-performance under those circumstances. So we've talked about impossibility, but now let's kind of bring it back a little bit, and recognizing that physics isn't the only time that we are unable to perform contracts. Sometimes it's just really impracticable. Just doesn't make sense. Yes, it can be done, but why would you want to do it? Again, going back to the example of the barn that was damaged by the tornado, but it's still standing. I can paint it, but why would I? Doesn't it make a lot more sense to repair it, to replace the missing boards, to replace the windows, to do all that stuff, and then paint it? That would make more sense. That's what the parties probably want to do, and probably what they would really do in that situation is do a novation. They would say, listen, I know you were supposed to paint the barn on March 17th, but the tornado came through on March 15th. We've got some repair work to do before you paint the barn, so can we just delay it a month? And most likely the painter would say, okay, that makes sense to me, and go about with changing the date. But in theory, if one party was unwilling to make the change, then you could say, well, the contract performance has become unrealistic because of unforeseen circumstances. Now, there are a couple of things to point out here. First of all, we're talking about a big inconvenience. We're not talking about, gosh, the price of paint has gone from $30 a gallon to $35 a gallon. That's not going to cut it. The courts would say, listen, you should have figured that in. You should have considered the possibility that paint would go up when you were calculating the price. Or if you didn't want to bear the price of the price of paint the risk of the price of paint going up, you should have had the other guy bear that, and have a provision in the contract that says that the amount of compensation you're going to get is going to increase if the price of paint goes up by this much or that much. So unrealistic isn't an easy hurdle to reach. The second thing is it has to be unforeseen, not just your run-of-the-mill, hey, you know what, every spring there's a big rain and a flood and that barn gets messed up. Well, if it happens every spring, you could have foreseen it. Of course, one thing that can happen in these situations is the parties can anticipate it, and they can have contractual language in the contract to address it. In those situations, then this issue becomes moot because you're just going to look at the terms of the contract. Courts are loath to do this. They want to enforce the requirements. They say, hey, if you wanted a way out, if this or that happens, guess what? You should have negotiated that. So this isn't something that the courts are hammering or intending to do very often. Let's consider this last issue. This is one of my favorite cases in the whole course. I find it very fun. It gives us a little slice of history, I guess. This is frustration of purpose. Before I go into this, I want to say, though, that this example, which we're about to go through, is, as far as I know, the only time this argument has been used. So please don't think, oh, yeah, this must be all the time, really, really popular to use. Certainly, you can advance it, and there's no reason why you couldn't be successful, but I don't want to oversell this and cause you to think, wow, this is permitted all the time. So let's go back to the early 1900s. I don't know if it was Queen Victoria who had passed away, but anyway, some English royalty had passed away, and now it's time for a new king. Well, as you can imagine, these events, are pretty big deals in Great Britain, especially back then, because, the king wasn't just a figurehead. I mean, he or she actually had some legal authority. So after we'll say it was the queen, could be wrong about that, but we'll say the queen dies, Yeah, they're not ready to immediately do the coronation. I mean, there's a period of mourning the loss of the ruler, and also there's a lot of plans to be made. So anyway, they start planning for the coronation or the crowning of the king. And of course, it's a big deal. People are going to have, for the most part, everyone's going to have that day off. People are going to go to London. People who live in London are going to be lining the streets wanting to see the king either on his way to be crowned or on his way leaving the cathedral, I guess, where they would crown him. As a result, the route of the carriage that the king would be riding on was through large portions of London to give, as many people as possible the opportunity to see the king in all of his finery and all of his regalia, all those things. As you can imagine, once the route of the parade becomes known, there are people who are kind of staking out their territory. They want to make sure they have a good spot, and let's assume that these are some of these are wealthy people. They still want to see the king, and so they start noticing on the parade route there are some hotels along the parade route. And they think to themselves, why don't we rent a room in one of these hotels, one of the rooms that face the road? Then we can be for sure that we will have a good viewing of the king, and we won't be kind of squished, and we won't have to be there hours early, and we won't have to mingle with the peasants below us and all that kind of stuff. So several of these wealthy people reserved or rented rooms in these hotels facing the route of the coronation carriage. The hotels, of course, got wind of this and thought to themselves, this is an opportunity for us to make more money. And so they thought to themselves, listen, the rooms that face the route, we're going to charge maybe 10 times as much as we ordinarily charge. For our other rooms, the rooms that face the other direction, we're just going to be charging the normal rate, because from those rooms, people won't be able to see anything. So those people who stay there are just staying at the hotel, maybe so they can walk down and stand along the street. So there were these kind of two rates: the high rate if you were on the road, the low rate if you were facing the other way. Unfortunately for all concerned, most especially the king, he developed appendicitis. And back then, of course, this was a very dangerous disease. People died from it, even kings died from it, but he didn't die from it, fortunately. But obviously they had to cancel the coronation, or I guess delay the coronation until he returned to health, which took several weeks. So they canceled that coronation, and then eventually they planned for another coronation a few weeks later. The people who had rented those expensive hotel rooms on the route didn't want to pay those high rates at this time, because their point was, hey, the only reason we rented those rooms was so that we could see the king. There's no king to see on that date, so we don't want to pay for those rooms. The hotel goes, well, you told us you wanted them, we reserved them for you, you agreed to pay this amount, you need to pay it. And so this became a lawsuit. And the court in England said, no, the renter of the rooms did not have to pay those exorbitant rents, because the purpose of this whole arrangement was frustrated. These people didn't rent these rooms because they wanted a hotel room. They rented these rooms only so they could see the coronation of the king. And it was certainly unforeseeable. Who would have thought a relatively young man would become ill right before he becomes crowned? And again, the issue is, does it defeat the objective of the parties? So again, this is what frustration of purpose is. But don't hang your hat on this. As I say, this is a rare theory to win on. You can see how fancy the carriage was, and you can see all of the royal guards lining the roads, and behind this would be the people watching. And you can see, if you were in one of the, say there was a hotel building here and you were up here on the second floor, you could have a better view of the king, maybe looking in and seeing him pass by. Okay, let's consider another failure of another discharge by non-performance, and this is failure of condition. We talked earlier about condition subsequent that turns a duty off. and conditions precedent that turns a duty on. Here we're talking about condition precedent, but I suppose you could talk about a condition subsequent that actually happens. Anyway, something that either fails to happen so the duty never gets turned on, or something that does happen that turns off the duty. So under those circumstances, you can have discharge by non-performance, meaning, let's say, again, going back to my example where someone is going to buy a house from somebody, but as part of the negotiations, they decide that the buyer doesn't have to buy unless he or she is able to secure financing. That's a condition precedent. If he or she is unable to secure financing, the contract isn't going to go through. Well, in that situation, if the buyer isn't able to secure financing, there's a failure of condition, and his or her non-performance is going to be discharged because the condition doesn't happen. Okay, so we've already seen this definition of breach. It's the violation of a duty or obligation, especially related to contract law. It has to be material. In this situation, we don't mean cloth, we mean importance, a significant part of it. We're not looking at the substantial performance area where you've done almost everything, but just a couple of T's weren't crossed, a couple of I's weren't dotted. No, we're talking about something big deal. For example, look at this tattoo. Somebody hired this tattoo artist to tattoo something that says "too cool for school" and put a school bus on it. Pretty sad looking school bus, but the real problem is, of course, we're missing an H here. So I would say that that is a material breach. I think most people getting a tattoo that says this probably would have wanted a better bus, but even if the bus was okay, they're going to be pretty frustrated by the misspelling of the word school. So let's consider that Ted is the tattoo artist, and Bob has gone to Ted to get this tattoo put on. And Ted is instructed to write "too cool for school," but Bob gives Ted the information with an H in school. And Ted just forgets about the H and tattoos Bob without it. Under those circumstances, I would say that's a material breach. Ted is in material breach of the agreement. I mean, it's true, probably Ted didn't intend to leave off the H. Maybe he forgot. Maybe he was distracted. Maybe he doesn't know how to spell school. But whatever the reason, even if he didn't intend it, he's still a material breach. And so under those circumstances, you could argue that Bob's duties under the contract are discharged by Ted's breach, by Ted's non-performance. So under those circumstances, we have a discharge of the obligation by Ted, the tattoo artist's failure to spell school correctly. Let's consider the issue of anticipatory breach. This is one of my favorite pictures that I have on my PowerPoints. Imagine for a second, we're going to call this lad Peter. Peter gets home from school. He a little hungry, wants a little snack. His mom says, and he says, "Hey mom, can I have an ice cream sundae?" Mom says, "Well, Peter, I don't know if that's a good choice. It's not too long until dinner." And Peter goes, "Oh, I'll still have a good dinner, I promise. Come on, Mom, can I have an ice cream sundae?" Mom's a bit of a softie, so she goes, "Okay, Peter, you can have your ice cream sundae as long as you eat everything on your plate. We're having pork chops and mashed potatoes and broccoli. Do you promise you'll eat all those things?" Peter, of course, says, "Sure, Mom, I will eat all of those things if I can have my ice cream sundae now." Okay. So Mom permits Peter to have the ice cream sundae. Peter eats his ice cream sundae. It's dinner time, and Peter has a lovely plate of nutritious pork chops and heavenly mashed potatoes and delicious broccoli. And Peter knows under the terms of the contract he needs to eat his broccoli. His mother, in fact, even offers to spear the broccoli and bring it to Peter's mouth. But we can see Peter is not having any of that. He is not going to allow that broccoli to somehow accidentally find its way into his mouth. He is guarding his mouth with great care and precision. And so he is anticipatorily breaching his contract. Even before the broccoli gets to his mouth, he's saying, not going to happen, Mom. I mean, you could argue he's only breaching when the broccoli is turned away here, but Peter is letting his mother know even before that moment where the broccoli either goes into the mouth or not. Mom, this is not happening. I am going to repudiate my contractual obligations even before I have to perform. So let's consider the definition of anticipatory breach. The announced intention of a party to a contract that it does not intend to perform its obligations under the contract. Okay, so we have Peter here, but let's not dwell too much on Peter. Let's consider a business example that might be better. Imagine that I have a widget factory, and my widget factory has 4 widget presses that make the actual widgets. It just so happens that I am supposed to produce 1,000 widgets and deliver those widgets to Luis's factory on June 1st. And it takes me about a day to produce 1,000 widgets when all 4 of my widget presses are working, which is the vast majority of the time. I don't have a lot of problems with downtime with my widgets. So since they're due June 1st, I was planning on starting making the widgets around March 28th. That way I have a couple of days if something untoward happens, but I don't need a ton of time. So on March 28th, we start gearing up our widgets machines to start preparing these widgets for Luis. And we actually get through and maybe do 200 of them. That night we go home and there's a big fire. There's an electrical storm and my widget factory burns to the ground. The 200 widgets we've prepared burn to the ground. All 4 of my machines are destroyed. There's just no way that I'm going to be able to deliver the widgets by June 1st. It is now March 29th that I'm able to evaluate the situation. I'm sorry, May 29th. I'm able to evaluate the situation and see that there is just no way. I mean, I only have 3 days to get everything in line, and it's not going to happen. Under those circumstances, I'm probably going to call Luis and say, hey, Luis, just to let you know, I owe you 1,000 widgets in 3 days, and I'm not going to be able to supply any of those widgets. Now, do I have an obligation to do this? No, I don't, unless, of course, there's something in the contract that requires that I do this. I'm not required to perform at all until June 1st, so I have no obligation on May 29th to tell Luis anything, or even on May 30th, or even on May 31st. It's only on June 1st that I am in breach. So you may say, well, why would I alert Luis to my breach before I have to? There's a few reasons. One reason is just kind of a business reason, which is maybe I'm hoping that I'll be able to rebuild my factory. I'd like to retain Luis as a customer. Maybe I will, maybe I won't, but I increase my chances of retaining him if I'm honest with him from the get-go. If I withhold that information from him until June 1st, he might say, why'd you wait 3 days? You could have told me earlier. I'm ticked about that. And even though he might have forgiven me for the fact that I was not able to supply the widgets, because after all, how could I have anticipated the fire? But he might still be mad at me because I didn't tell him promptly. So customer service becomes an issue. It may make sense to anticipatorily breach so I can keep a customer that I might otherwise lose. But that isn't a contract law issue. That's more of a business issue. From a contract law issue, there's advantages to anticipatory breach as well. If I give Luis as much notice as I can, it increases the chances that Luis can mitigate his damages. He can go out and find other widgets from other suppliers. He knows on May 29th that he's going to need widgets. If I had waited until June 3rd, he will have, I guess, was it 3 fewer days to do it. So maybe, I don't know how good the market is for widgets. He might actually, if there's a factory that's maybe a little bit on the light side, he might be able to get his widgets by the June 1st date. In any event, he's going to be 3 days ahead of whatever the timeline would have been if I waited until June 1st. So that means that he's going to be able to mitigate some, possibly even all of his damages. If his damages are reduced, then that means the amount of money I'm going to have to pay him for my breach is lower. So it makes sense for me in terms of damage management that I want to let him know about it as soon as possible. So those are the reasons why I would want to let him know ahead of time, why I'd want Luis to know ahead of time. But there's an important reason why I might want to wait, and this would happen when it's not 100% clear that I'm going to breach. Because once I notify him about the breach and I make it unequivocal, then that's starting Luis's obligations to mitigate. If I tell him my factory's burned and there's no chance I'm going to be able to produce the widgets, Luis can and should and most likely will start finding other sources. If it ends up that, gosh, some of my machines weren't that badly damaged, and you know what, I actually can produce widgets, and maybe I was able to produce 500 of the 1,000 widgets and deliver those on June 1st. But Luis has already found another contractor, a supplier of widgets, and so he already has another contract for the 1,000 widgets for someone else. He doesn't need those 500 that I am able to make. You can see how I have reduced my ability to complete the order. So when it's unclear whether I can satisfy the contract or not, whether I'm going to have to breach or not, a judgment call has to be made. Is the downside of breaching so bad that I may want to anticipatorily breach to reduce the damages, or is the possibility that I'm actually going to complete it high enough that it makes sense for me to take the risk? Sometimes anticipatory breach doesn't happen because Peter puts his hands over his mouth, or I call Luis and tell him my factory burned to the ground. Sometimes there's indications external to communications that let everybody know. For example, if I file for bankruptcy, or I'm seems to be insolvent, and maybe people in the industry would know that I'm financially insolvent, that can be a sign of anticipatory breach. Of course, this would fit more with Luis than with me. If Luis is on the verge of bankruptcy, and so if I supply the 1,000 widgets and he's not able to pay me, I don't want to supply them to him. I mean, yes, technically he hasn't breached. Let's say each one of the widgets is worth $10. So when I supply 1,000 widgets, I'm supplying him $10,000. Under the terms of the contract, he's not required to prepay me for it. But if I give him the 1,000 widgets and he's insolvent, he's not going to be able to pay me the money. So that can be a sign that when he's insolvent, that he has anticipatorily breached. He's basically telling me, without telling me, that, hey, don't give me those widgets because I'm not going to be able to pay. If a person seems likely to anticipatorily breach, again because of insolvency, or it's all over the papers that your factory burned down, then the other party absolutely can demand assurances that there's not going to be an anticipatory breach. And if those assurances don't come, then again, it's pointing to the fact that there is going to be an anticipatory breach. As we said before, the non-breaching party can get substitute performance, and in fact, it's actually required to get substitution under those circumstances to accomplish mitigation. So here we have a lad. Let's assume that he has heard from Santa, hey, I'm not going to be able to stop by this time. The lad still looking for Santa, but he knows Santa's not going to be coming. You can see there's still wood in the grate. That would be an example of anticipatory breach. Santa's told the little boy that he's not coming this year, that maybe Santa's sick or something and not going to be able to be there. So now we've covered the situations where we have discharge by non-performance. Impossibility, the laws of physics, or just the laws, prohibit performance. Impracticability and frustration of purpose closely aligned, both really rare. We have the coronation cases here. We have maybe high raw material costs or things along those lines. We have the failure of a condition precedent didn't happen, or a condition subsequent did happen. And then we have the breach of contract. Again, that could be anticipatory breach, or it can just be your normal breach. So now we've covered, in our plana, we've covered our plain part, and we have our final one, the operation of law. This is by no means an exhaustive list. These are just a couple of examples. As you can imagine, there are hundreds and hundreds and hundreds of these, but this gives you a flavor of how a few of those might work. So if a person files for bankruptcy, so let's say Sally files for bankruptcy. And Sally owes me, or she owes me money under the terms of a contract. Let's say she's supposed to pay me $1,000, But she owes lots of creditors money, and she has relatively few assets. She doesn't have a dollar for every dollar that she owes her creditors. And so through the bankruptcy process, maybe she pays, 10, 20, 30 cents on the dollar. She owed me $1,000 and she ends up paying me $150. And that is supposed to satisfy the amount that she owes me. I don't feel very satisfied. I feel like I'm due $850 more. Not a very happy feeling for me, but once she pays me the $150, she has been released from her contractual obligations. Her duty is discharged, even though it is not nearly the full amount of money that she negotiated, and that's because the bankruptcy law has discharged it. As you can see, I am her creditor. I'm not very happy about this, but I don't really have any way around that. I'm stuck with that outcome. Then we have a statute of limitations. These again are statutes. You can see that they're statutes by the name here, that prescribes the maximum period of time in which various types of civil actions and criminal prosecutions can be brought after the occurrence of the injury of the offense. So if I wait too long to sue Sally, then Sally doesn't have to pay me, even if I have really, really strong evidence. We talked before about prohibition. That would be an example of another operation of law that makes a contract illegal. So these are just a couple of examples. There's lots of others out there that I could have added to the list, but the textbook just goes through these two, so that's what I wanted to share with you. But don't think that these are all of the ways that laws can impact contractual obligations. So now we have completed all of the ways we can have discharge, the Plano circumstances: performance, agreement, non-performance, and operation of the law. Contract modification. We've kind of already talked about this one. Here's that picture of, here we have Michael. I guess Michael has a little sister, and here we have John Ritter. That's the other actor. We can see this is for the second movie, Problem Child 2. So here we're going to talk about contract modification. We talked about this as a novation, and it certainly is a novation, but we're going to consider it from the enforceability of when we modify a contract. So to avoid a breach, parties may agree to change the original contract's terms. And we saw this with novations. Remember, someone broke his leg or her leg. Go back here to our original story. So B broke the leg. B had the lawn service. He was mowing A's lawn, and A was paying B the amount of money. B's leg got broken. He's not going to be able to mow the lawn. So C comes in. He assumes the same duties that B was doing, and A agrees to pay C. B is out of the contract. He has no continuing obligations into the contract. So that's one way that we can have a contract modification, but we could have modified it in a different way. For example, let's say this isn't a lawn mowing situation. Let's say this is B is painting a portrait. So let me go ahead and here we go. So, but B has some arthritis. And so B says to A, hey, if you'll give me a little bit more time to finish this painting, I can still do it for you. And then A goes, yeah, I still want you to complete the painting. I'll give you another 6 months to complete it. And so B takes his time, works on the days that he feels up to working on it, and he is able to complete the contract. Now, when you have a modification like that, you're going to need to have some additional consideration. A is giving B more time, so that's the consideration that A is providing for the second contract. What is B giving A that B had not already agreed to provide? That's what we're going to look for. And that's what we had. That was the issue that we had in this particular case. The enforcement of a modification depends upon circumstances. It cannot be made under duress or in bad faith. You may recall that Universal Studios said, we were under duress. We were between a rock and a hard place. We were supposed to be making this movie. The Michael was the problem child. Some states require new consideration. So if one party's going to give more money, the other side's got to give some service. Again, the court's not going to parse and weigh and say, well, which one is worth more, or things like that, but there needs to be something. Again, we have consideration not so much because the court is focusing on, is this a fair deal or is this a good deal, but more so, did both parties get the fact that they were making a contract, or in this case, modifying a contract? The modification should certainly be in writing. That probably doesn't have to be legally in writing unless the statute of frauds kicks in, but it's obviously a best practice, again, especially if the original contract was in writing. But even in situations where you have to have the new consideration and maybe you don't, courts can consider a few ways around this problem. And so the courts have the ability, usually through kind of an equitable fairness idea of saying, even though maybe every I was dotted, every T was not crossed, we're going to enforce this contract modification under these circumstances. So let's consider the issue of waiver. The intentional relinquishment or renunciation of a right, claim, or privilege that a person has. If I waive my rights to something and I do it very clearly and unambiguously, while I'm not under duress or the other guy's not acting in bad faith, the courts may well say, I'm going to honor that contract modification. Then we have estoppel. Whenever you see the word estoppel, look for the middle word in here. The word stop is in the middle of estoppel. And we also call this estoppel by contract. And prohibition against denying the validity or significance of acts done in performance of a contract. So when one side goes ahead and honors the contract modifications, so party A honors the contract modifications and party B doesn't say anything, and then after the fact goes, oh, wait a second, that contract modification really wasn't good, that's when the courts will be like, wait a second, you could have stopped this, you chose not to, so we're going to stop or stop you from complaining about it. So there is the possibility, even when you don't have new consideration for one of the parties, that a contract modification may still be enforceable. But that's not where you want to be. That's not where you want to take your clients. You want to have that additional consideration, keeping in mind that it can be a pretty symbolic consideration. I mean, it doesn't have to necessarily be the crown jewels to get it done. So when you're drafting contract modifications, always be sure to include new consideration for both parties. So now we've covered both topics in our chapter, performance and discharge. On the practical side, let's consider some provisions that you may well want to consider having in your contract in the performance section. And again, this is usually something after the introduction and after the recitals, but before some of the boilerplate language. Usually the performance section has a lot of individually drafted for this particular contract type language where we say Bob is going to do X, Teresa is going to do Y, that type of thing. So you want to have termination and discharge. How does somebody get discharged out of this contract? How does the contract terminate? What conditions? Conditions precedent, conditions subsequent, conditions concurrent. What happens when the condition precedent doesn't happen? How do we know when the condition precedent has happened? Who has obligations to try to make the condition precedent happen? How do we know when the condition subsequent has happened? Are there any obligations with respect to averting the condition subsequent? When the condition subsequent does happen, what's supposed to happen under the terms? If it's some kind of release, we want to make sure that we are clear about what the accord is and also when the satisfaction should occur. And of course, if we have a novation, we want to be clear about that, making it obvious that the other contractual obligations are discontinued. And you'll find in your textbook examples of these clauses. It's a good practice, actually, as you if you choose to have a career drafting and working on contracts, is to have, to pull out these provisions in contracts that you think are helpful or are ones that you may want to use in future contracts that you actually draft. These are kind of boilerplate contracts. Form books would provide these, and they can be very helpful. No point in reinventing the will or drafting language that already is readily available to you. So this is the end of Chapter 9. I hope that this has been helpful for you. As always, if you have questions, feel free to drop me an email or feel free to come by my office hours. I'll be glad to field any questions that you might have about the material. Thanks for your attention today, and I hope you have a wonderful day. Take care.